Subscribe to this channel.
Spoken with my client, these parties have, from what I can tell, after speaking with my client and the guardian ad litem, parties have issues communicating with one another. There's a lot of adversarial behaviors. We would argue mostly from Mr. Conti, but I know that both sides are held responsible for the court. But it's just my belief, based on what I know, that mediation would not be successful in this matter. It would just be essentially a waste of time and money. And I know the court favors mediation, but I would not bring this motion lightly before the court. If Your Honor needs any testimony, I can put my client through.
I don't need any testimony. Mr. Conti.
I object, and the reason I object is they attempted this at the last hearing we had with Judge Wallace.
Attempted what?
To waive mediation. Judge Wallace says, no, we're going to do that. We're going to have mediation. They didn't want to do the opposing side did not want to do.
Has there been a motion to waive mediation heard by Judge Wallace?
It was a verbal.
No, I don't believe so. It's been a while, but I don't believe I ever filed a motion like that.
No, there was no motion filed.
If I may, I haven't said anything, but what we had was I did a motion to get an amended scheduling report. And so that's what we did, was to extend deadlines so that we could get the mediation, because at that time we thought we were hopeful they could come to it. But since then it appears that that's not going to happen.
Your Honor, the motion that was filed by the guardian ad litem was to force me to pay for the remainder of that psychiatric evaluation. And I explained to Judge Wallace at that time, this was it. I totally disagree with it.
And Judge Wallace instead of Judge Wallace?
No, sir. No. So I'm just relaying what happened. I'm sorry, I don't understand all the rules of the court. I am very poor, and I have a meeting scheduled with an attorney, and I'm borrowing a bunch more money. I'm under this injunction, and I can't do anything. And I have assets, and I can't do anything because of the injunction. However, Judge Wallace specifically stated we do this for mediation. The guardian ad litem said that they were in court, said that she was going to attempt mediation in November. I contacted the mediator. The mediator had not heard from anybody. I went and started that.
You understand what mediation is?
Yes, sir.
What is it? It's
mediation where we try to work through these things. Now, this is the thing. There has been absolutely no aggression from my part, not one. And Ms. McLeod just said that it was from my part. And I would just ask, is there any physical evidence besides all the words? Because there's a whole bunch of accusations that keep being lobbed about me. But there's no.
I'm asking you if you know what mediation is. It's not a trial. Mediation is just negotiation.
It's a negotiation with the mediator.
The mediator can't force anybody to agree to anything. It's not arbitration. It is a mediation. And if a mediation is one that if the parties are unlikely to be able to reach an agreement because of the differing views on what the evidence is, then mediation is a waste of time and money for the parties. You can still negotiate. You just don't have to pay someone to sit in as a mediator.
I've never been asked anything to negotiate anything yet.
What I will point out is this: I am not going to waive mediation if this case is going to go in front of a different judge, because the judges that have to hear the final hearing differ sometimes on whether or not. Judge Wallace firmly believes in mediation. I tend to think that mediation is successful when the parties have open mind and they believe that there is a basis for it. Where one side says there's never going to be an agreement reached based on the positions the parties are in, it's, in my opinion, counterproductive to order that you spend the money to hire a mediator, go and spend a couple of hours negotiating back and forth with no success, and you've just put an additional delay as far as an additional expense. But sometimes it does work that you force the parties to go in, and an impartial third person, the mediator, points out differences in the position to each of the parties and causes them to say, well, if that's what the mediator thinks, then the judge may have the same opinion, and then causes the parties to come to an agreement. So I'm not saying it never works. I'm just simply saying it usually requires both parties going into it with an open mind and a willingness to do it.
Well, ma'am,
So I'm not finished
I'm
talking.
sorry.
So under the circumstances, it seems to me that it depends on who the judge is that's going to hear your final hearing. Judge Wallace has heard numerous hearings in this case. And if I'm hearing correctly, is that right?
Judge Wallace heard the order of protection hearing at the very beginning, and there's been no further hearings.
He's not had any other hearing.
No, we've come to court before on the scheduling orders, if I'm not mistaken. And there's never been anything else.
Discovery disputes and stuff like that.
Like there's never been, we've never had a hearing in front of Judge Wallace, which, and I'm aware that Your Honor would not want us to go to different judges and things of that nature. So I would not put these motions in front of you if he had heard anything substantiated as to this particular section.
Well, number one, you're not likely to get a trial date from me until next year, and I don't have my next year calendar concluded. So
Yeah.
your motion to waive mediation and to set for a final hearing is just going to be reserved because I can't give you a final hearing date anyway, and it depends on who the judge is going to be as to whether or not the mediation would be waived. So,
Okay. So
all
just,
right. Have a seat, Mr. Conti. We now are on the motion to order that for an order controlling conduct.
yes.
You want to be heard on that, and if you want to put on any proof about it, then we can do that.
Yes. Your Honor, I would call Ms. Conti, Tina Conti to the stand.
Ms. Conti, if you'll come forward, please. Any reason we can't have all of these at one, or do you want to bifurcate the hearing? That is Mr. Conti. Let him come on up. That's the one of the parties. So.
I did want to make a preliminary motion on the order of protection. Then if you're, just depending on how Your Honor rules on
Down at
that.
the podium. Go to the podium.
And if you want me to go ahead and start talking, or, okay, so Your Honor, I want to make a preliminary motion on the order of protection that was filed by Mr. Conti this past week. Depending on how Your Honor rules on that, I'm fine with keeping them together if you don't grant my motion.
What is your motion?
I would ask Your Honor to dismiss the ex parte temporary order of protection that was granted by Judge Turnbow. The reason for that being, Mr. Conti knows that I'm the attorney of record on the underlying divorce. Mr. Conti did not give me a copy of that motion. I found out about it this morning. I'm sorry, the order of protection. I found out about it this morning. Another reason is Mr. Conti filed 2 motions this past week on the same day, and about 10 minutes prior to the order of protection, he brought the motions down to my office at the district attorney's. He did not bring me a copy of the order of protection. My argument would be exactly in bad faith, and that his motion be dismissed. And I believe there's Tennessee Supreme Court Rule 2.09, I think, which I have a copy of, which deals with ex parte matters.
Well, there are minor children involved in that order of protection. Are they in the courtroom?
Yes, everybody's.
They need to go outside. So.
And I would ask that anybody who's here just to testify also be ordered outside.
Anyone who's going to be a witness other than the parties in this case must go outside of the courtroom and remain outside of the courtroom. You're not to discuss the testimony of any other party with anyone until you yourself have testified. Counsel and Mr. Conti will be obligated to make sure that the rule is complied with. That includes they're not to be watching anything on YouTube out in the hallways. You may have to step and make sure that they'll, I don't think they can because they don't have their phones, but I would think. All right. Then Mr. Conti, what is your response?
I object to the motion. I am not aware of, I didn't know if Tina Conti had hired Mrs. McClure to represent her in the order of protection. This is also, I feel, another method to silence my children. My children wanted to speak here. There is CPS involved and Department of Child Services involved. They are actively investigating many accusations of, and they feel that there's a credible accusation of child abuse.
Yes, that's fierce.
Can't testify about what or state what somebody else is saying unless they're here as a witness.
In addition, I subpoenaed the caseworker. She explained that she could not come unless she was subpoenaed. We executed the subpoena when I found this out. they didn't serve the subpoena to Stewart County. And to be honest, I don't know that the subpoena was, I don't know that the temporary order of protection was served to Tina Contact. I was told that we would get it, I would get an email, check the email repeatedly. I haven't seen it. And I did this on the request of my daughter. My daughter asked me, this is very serious stuff. I do not hold it. There was a lot of trepidation with me even doing this. I understand the emotional toll that it's taking on my children. I know what it's taking on me. I also understand the emotional damage that it's causing my wife. We've been constant prayers trying to make sure that this thing goes as expeditiously as possible. However, my daughter wants to speak, and she has a guardian ad litem that she doesn't want to speak for her. This all started because there was a temporary order of protection that Ms. McCloud. I'm sorry. I'm so sorry.
Step up to the podium.
That the opposing attorney filed against me. It was upheld by Judge Wallace without any physical evidence, no written evidence. It was only on the word of my wife. The accusation of violence after knowing this person for 30 years, the only accusation was that I touched the tip of her nose.
All right, you are going into a lot of more information than I need to make a ruling on the motion to dismiss. Ms. McCloud, the motion to dismiss is going to be reserved simply because of the fact that orders of protection are extraordinary remedies, as I've said many times, and they're there for the protection of individuals who are victims of domestic violence. So I will hear it. We're gonna have a hearing, and I'll hear whether or not there's any evidence of domestic violence, and then we'll go from there. But there are other remedies besides an order of protection that can be implemented in certain situations. Restraining orders are orders of the court. And for that reason, it seems to me that it's going to be imperative for the person seeking an order of protection to show that the statute, that the facts of the case meet the statutory definitions involved in an order of protection. So your motion to dismiss at this point is respectfully denied, but reserved for further hearing. Then we have a seat, Mr. Conti. Then we have Mr. McCloud. You have a motion to waive mediation and set for trial.
Yes, Your Honor, I have 3 motions.
You also have a motion for order controlling conduct and a motion to request that the father submit to random drug screens and complete the mental health treatment.
That's correct, Your Honor.
You want to at least address, obviously some of those are going to require some sort of testimony, I assume, but do you wish to address any of those motions?
Well, Your Honor, if I may address the motion to request father submit to random.
Is your client here?
Yes. Ms.
Have her come on up.
In regard to the motion to request the father submit to random drug screenings and complete mental health treatment, the reason for that motion is based solely on the recommendations of the Rule 35 psychiatric examination of Mr. Conti that was completed a few months ago, but which was just filed with the court, I believe, in August. That's the only basis for that. It's following the recommendations of the psychiatrist. Dr. Stephen Montgomery.
All right, Mr. Conti, the court has previously ordered, it was a different judge, but the court has previously ordered that you undergo a rule, what we call a Rule 35 examination, psychological examination. And that evaluation was performed by Dr. Stephen Montgomery. And that has now been filed with the court as of March of this year. Have you seen that review or seen and reviewed that evaluation?
Yes, sir. Yes, sir, I have. And then I became aware that the other parties had my evaluation, but I didn't have her evaluation. When I took the evaluation, well, first off, when I was in front of this court and you, honorable judge, I requested that I have a psychological evaluation done by another provider. When we were in this hearing, the guardian ad litem said, no, we need to have this done for December 5th hearing, okay? I agree, and the reason was because it was excessive, and I didn't feel that it was organic. I feel like this is all lawfare. This is coming after me because my wife abandoned me many years ago. She took the kids from me, and she continued to keep the children from me. So
Have you reviewed the Rule 35?
Yes, I'm sorry, yes.
Did you see what Dr. Montgomery says about, and do you disagree with any of his findings?
I wholeheartedly disagree. I recorded the entire interaction with this doctor through the very beginning when I got in the garage, through the whole entire evaluation. He has left out so much information, and it's errors of omission. There are complete lies in this. Now, there are complete lies in both of these, and I would love to have a hearing on the validity of this. Absolute false, left out complete omissions. Now, I have gone through psychological therapy on my own, and I've done this my entire life. I did all of the medicine that I was expected. Is this the time that I speak about this? I'm sorry.
No, I'm just trying to determine. You're saying you're under psychological treatment currently?
No, sir.
How long has it been?
It's 2008 is the last time that I had any 2008, I was prescribed alprolizine. Okay, this is after many years of going through doctors. Okay, I had a drug interaction in 1999 because the medicines they gave me caused me to have a medical-induced suicidal ideation. This has grown into this lie that I'm suicidal to this day. This lie has continually said that about me to my children. Okay, this is a drug interaction I had in 1999. I was under psychological therapy with a psychiatrist and a psychologist that I paid for and initiated upon my own. I went through therapy. Then there was no more reason for me to go through therapy. I had worked through the issues, okay? Then my father was killed and I was having anxiety attacks. So I went to the doctor, they gave me medicine. Then I became addicted to the medicine and I said, I need to stop taking that medicine. I stopped taking that medicine. In 2018, I administered myself magic mushroom therapy for me to heal for myself with my problems with anxiety and depression. After that experience, I had no other issues with anger, had no issues with anything. Felt incredibly great. I went to the evaluation. I explained all of this to the doctor. The doctor disregarded this within this report, and it's errors of omission, in my opinion.
What do you mean an error of omission? He makes reference to the fact that you have used magic mushrooms or whatever you call those psychedelic mushrooms.
Yes, sir.
He does make reference to the fact that you have done that.
But he doesn't make reference into the fact that started me on this spiritual path. And I live in absolute happiness the majority of the time. The only time I don't is when I'm listening to my children being abused nonstop. It's nonstop abuse within this. And this was all ordered because of a temporary order of protection that was upheld, and her attorney dismissed this on this without me having notice, because I was going back in with all the evidence that they said I was doing this abusive stuff. They dismissed it. However, Tina Conti continues to this day bring up this temporary order of protection. She has a temporary protection. If you look within her psychological report, she mentions a temporary order of protection. But what she doesn't mention in the report is that it was dismissed by them. They dismissed. They didn't ask me to go back. If I was doing anything, why didn't they continue with that? And in her psychological report, I got up to, I think it's 39 absolute errors in this. Absolute falsehoods, complete and utter falsehoods. Maybe Mrs. Conti doesn't understand that maybe there are some errors in there, and she'd like to say, no, these items aren't correct. But I am pursuing legal action against this doctor. This is libel. They are writing false stuff about me that I never said. During the interview, he was leading me into questions, and I asked him, what is this about? And he goes, well, I interviewed your wife. So now I get the report. And the very interesting thing that I would just ask you to review is the dates of the reports. The date, it was supposed to be performed by December the 5th. The guardian ad litem rallied against me not being able to pay $750, that I had to go to this guy. I feel that this is all a fix. This is the fix is in. Now, if you read through her report, you'll see there's some very poor editing in there. If you look at the second page, the last paragraph, it just picks up in the middle of a conversation, but they don't give you the context of the beginning of that conversation. It just says, Mrs. Conte said Stella then opened a kitchen drawer. How do we start that?
I don't know.
This is from Tina Conte's Rule 35 evaluation.
Who's
Tina Conte?
her contact?
Again, I would object, Your Honor. We're not here about this contact evaluation. We're here about Mr. Contact. That's who I thought most.
Mr. Conti, this is,
Okay, on my evaluation, there are a lot of.
just a second. We're here today on a motion to waive mediation, a motion for order controlling conduct, and a motion to request that you submit to random drug screening and complete mental health treatment as was recommended by the doctor who did your evaluation. Now, he has made a diagnosis, and I'm sure you saw that.
I saw that he's, yes, sir.
In the diagnosis that he came up with for you after his evaluation is that you suffer from an unspecified mood disorder, an unspecified personality disorder, that you have an alcohol use disorder, which is sustained in full remission, and that you have a cannabis use disorder and a hallucinogenic use disorder. You've had Lyme's disease, Rocky Mountain spotted fever, and alpha-gal syndrome. Now,
I'm a candida overgrowth.
pardon?
And a candida overgrowth, and I have Lyme arthritis, and my muscles are deteriorating by the day. I keep losing weight. I'm in physical therapy twice a week because of this. If the hallucinogenic use disorder, okay, I haven't used magic mushrooms since 2021. Additionally, I explained all of this to the guardian ad litem when I first met the guardian ad litem after the temporary order of protection. That additionally was the Tina Conte and Amelie Conte said a bunch of stuff about me, and I explained this all to the guardian ad litem. I also recorded that entire conversation. The entire conversation, I recorded that. If I'm so crazy, why do I record every one of my child's weekend visitations? I have audio recording for every one of those. It's because of the constant lies that have been said about me. I have not been abusive ever in my entire life to any woman or any child. And there will never be any proof to show that because I've never been that way, ever. His evaluation has bold-faced lies in it. He says that I have a history of violence. The history of violence he's referring to, I explained in this thing, there was a drunk person. I don't like alcoholics, and my father was an alcoholic, abusive narcissist. While my wife was pregnant, this person was pushing against her doing this thing. And I said, let's go.
So let me interrupt you and say this. I know that you have a lot to say, but what I want you to understand is we're trying to maintain focus on what the issues are before me. There is a motion down to require you to undergo random drug screening. My understanding is that you're saying you do not use any kind of drugs.
No, sir.
So would there be no reason that you would have any opposition to taking random screening?
I have no opposition to taking random drug testing. This is nothing more than more violations of my cyber
So
rights.
we now have both of you saying that you would be willing to take random drug screens, and if he's going to have to take random drug screens, she will too.
Okay, may I mention one other thing?
No.
I'm sorry.
Secondly, then there's a motion for you to complete mental health treatment. The doctor who performed your evaluation recommended that you have some additional mental health treatment. You saw that portion, I assume.
Yes, sir.
Now,
And-
I understand you disagree with his evaluation. Let me explain to you how things work. We have ordered, or the judge, I don't remember if it was me or one of the others, ordered a Rule 35 evaluation. The rules of procedure allow that to be done. We have sent you to a psychiatrist, or a medical doctor at Vanderbilt. He has performed that. You disagree with it, and I understand that. You have every right to have a second evaluation at your expense, to go and have an evaluation performed by an expert of your choice. And at that point, you would have the right to then utilize that in trying to contradict what Dr. Montgomery has said. If you decide to do that, you will be given an opportunity to do that. You will have to notify the adverse party, Ms. McLeod, and her client will need to be notified, and the guardian ad litem, because they have a right to know who it is that you're going to have the evaluation performed by. But getting up and saying, I have 35 disagreements, or where the Dr. Montgomery was just flat out lying about it, is just going to be your word against what he says in his evaluation. If you want to have a different evaluation that you think is more impartial, then you have every right to do that. I'm not going to order it, but I'm going to give you the opportunity to have an evaluation done. That's the normal way of the lawsuit proceeding. If one party has an expert who says something, and that the adverse party says, I disagree, I think he's wrong, then they have to then go, the burden's on them to go and get their own expert who will evaluate that situation, whether it's a car wreck case or a psychological evaluation. You have the right to get your own evaluator to do an evaluation. And then it becomes an issue of both of those presented to the court. And I'm not going to listen to a recording of you in 2.7 hours of meeting with Dr. Montgomery, because number one, had I done that, I would have sat in on the thing to begin with.
It's three.
The second thing is, if you have an evaluation that is performed, then you can have that person issue a written finding. And when we get to the final ultimate day, if you want to have subpoenas issued for both of those doctors, I will be glad to, or the judge who hears your final hearing will be glad to listen to both of them, determine which of them is the more credible witness, and we'll make a decision based upon those facts and the testimony of all of the other parties. But getting up and saying, I disagree with both your finding and her findings in the psychological report doesn't help me, because obviously that's your opinion.
May I point to one inaccuracy?
You may.
So if you read my report, there is one portion of it, it's called the personality assessment inventory. If you read that, none of this that the Dr. Montgomery said is listed in that. No issues at all. However, in her Rule 35, there are some issues, and I understand we're not on that. Secondly, I requested this court that I do have it done at another place that was cheaper. The only reason we went through this place is because we had to have the final hearing on December 5th. That was the second final hearing that was scheduled. This has been going on and on and on, and they're dragging this out. The first December 5th hearing, and it's always steered towards Judge Wallace. It's never steered towards another judge. Steered toward Judge Wallace. December the 5th, I had my attorney filed a motion for default judgment because they didn't answer the counter complaint, and then I filed a motion with. No, sir.
You wrote on that motion to dismiss based on not filing a counter to a counter complaint. You already wrote on that, I believe, in November of last year, and I could file an answer, so you dismissed that motion.
And this was a motion that was, pardon me, and I object to that because the motion that I'm talking about was filed with this court on the year before. This was done at a January 3rd hearing. This wasn't, it was in front of Judge Wallace. That was totally ignored. There was nothing in this, and I've gone back and forth with the clerk to make sure that this was in there. The first motion for default judgment was then, it was ignored, and then there was this motion for final hearing. I appeared to this court, and I disagreed with my attorney from the beginning. I said, we have not even attempted mediation, and we're scheduling final hearing. Can they answer the counter complaint? Because under the law, there's 30 days to answer the counter complaint. They didn't answer the counter complaint.
Why are you talking about this right now?
I'm showing you that there's these delays in this. So during during this time, someone anonymously called Department of Child Services against me. They came to my house on all these accusations. They gave me a random drug test right then and there. I did it. I'm not objecting to that. I use legal Farm Bill 2018 cannabis for my problems. I cannot take pharmaceutical medicines. I'm allergic to just about everything. I don't even use shampoo. I don't use deodorant. I don't use shampoo. I mean, I don't use a lot of stuff. I can't take ibuprofen. I can't take Tylenol. I can't take all this stuff because it causes adverse reactions. So,
I made your point about the fact that you're saying that this is being drug out and delayed. Now,
and I'm sorry to cut you off. And during that DCS thing, I asked them, would y'all please do the evaluation? They said, well, we can't because he did this. The last time that DCS was at my house, the DCS CPS, Jessica Lang, said that she's going to ask, since there is credible accusations of abuse, she's going to request new psychological evaluations for both of us. And I would just ask the judge to allow that to happen because I can't afford this.
Your Honor, I want to object again. We have not indicated what DCS is or is not going to do. We do have a child family team meeting scheduled with the Department of Children's Services, I believe on October 3rd, based on, I think, what's in the order of protection in part. But again, Your Honor, you have the procedural history of the case in the file. Mr. Conte was talking about things that happened last year and the year before. I would just ask the court to consider what's in the motion. I mean, Mr. Conte should be required to do what the recommendations of the psychiatric doctor are at this time. Your recommendations with this contact, if there was, we would do it.
Your Honor, my mother has bipolar disorder. My brother had bipolar disorder. Tina Conti has accused me of having bipolar disorder. All of this time, I went through psychological testing. My doctor.
you're telling me that someone from the Department of Children's Services has told you that they are likely to recommend that both you and Mrs. Conti undergo an additional psychological testing?
Yes, sir.
Yes or no?
Yes.
Now,
Under oath, I'm saying Jessica Lang told me this in my house the other day.
and that you understand that Ms. McLeod is saying that there is a team meeting of some sort of meeting with the Department of Children's Services that has yet to take place, and that may be when this recommendation is. If they recommend that you undergo and she undergo a psychological evaluation, you're willing to cooperate with that.
Of course. I have nothing to
We
hide.
have settled the issue about whether or not there's going to be another psychological. If the Department of Children's Services orders it, then they will arrange it and they will set it up and they can have a psychological. If they do not order a psychological evaluation of the parties, Mr. Conti is free to and entitled to obtain his own independent psychological evaluation if he chooses to. That
This is a psychiatric evaluation. I understand that those are a little different. It's not a psychological, it's a psychiatric.
Well, I'm sorry, I may have been, this is a psychological evaluation, a Rule 35 evaluation. So, Mr. Conti, do you understand what I'm saying? If the Department of Children's Services at this team meeting or whatever they have recommends the psychological evaluation, then the two of you will need to comply with that. If they do not recommend a psychological evaluation, then you will have the right at your expense to obtain another psychological evaluation that you think is more impartial than what you are alleged.
Yes, sir. And I'd like to also add that the team meeting that is scheduled on October the 3rd was initiated by Jessica Lang with CPS.
Doesn't matter.
It had nothing to do with this temporary order of protection. This is before that.
Doesn't matter.
But she just said it, so I'll just make
I
sure.
don't care what she said. You need to stay focused on what the issues are. You have an objection to the psychological evaluation. I'm simply saying if DCS orders it for whatever reason, if it's because they think there's an alien invasion coming in, they want to have you both evaluated, then you will both have the right to have that evaluation. If they do not order an evaluation, then you have the right, and I'm granting you the right, to have a separate independent psychological evaluation at your expense. You will have to notify Ms. McLeod and Ms. Coffenberry that you are going to have this evaluation because they have a right to have input into that, because if you go in and only tell one side of the story, a psychological evaluator can't always, make a determination. So they'll have a right to have input to that. So that is the ruling I'm making. Now, as far as his psychological, his mental health treatment, Ms. McLeod, it seems to me that this is kind of premature until we determine whether there is going to be another psychological evaluation. He disagrees with Dr. Montgomery, and I'm going to put some orders down regarding the conduct situation, but as far as him ordering him to have to undergo medical treatment, that he disagrees with the psychological evaluation and wants to have a separate psychological evaluation, either through DCS or at his own expense, then I'm not likely to say he is required by court order to have to undergo that psychological evaluation. But if he doesn't, and there's no differing of it, then that's a factor that the court will consider at the final hearing. If there's no other psychological evaluation, then, and he's failed to comply with any sort of further follow-up treatment, then that's a factor that a court, whoever the court may be, that here's the final hearing, will consider in making a determination of the case. Do you understand that?
Yes, sir.
All right.
Thank you.
Now, let's,
May I ask if there'll be a timeline set on that, so it's not.
when is your meeting with the Department of Children's Services?
I just thought there's a second.
Yes, Your Honor, it's Wednesday, I think at 4:15.
Day after tomorrow.
Yes.
All right. Mr. Conti will have 15 days from today's date to decide whether or not he wants to have an independent psychological evaluation. That'll give you a chance to find out whether the department is going to order one or not.
And if, Your Honor, if Mr. Conti fails to do that, may I bring this motion back before the court at a later date?
I'm sorry,
If Mr. Conti fails to do that, may I bring this issue before the court at a later date,
what issue?
of whether or not he should be required to comply with the recommendations of the.
Well, his failure, if he doesn't get a psychological, I want to make it clear to everyone. There is a psychological evaluation performed under a court order pursuant to a Rule 35 court order that says that Mr. Conti needs these things. If Mr. Conti chooses not to do those things, that is a factor that the court will consider at the final hearing. If there's a court order down that says he should get mental health treatment and he doesn't have another follow-up psychological evaluation that is contrary to Dr. Montgomery, or that says something different than that or makes a different recommendation, if there is no follow-up psychological evaluation, then we are proceeding under that Rule 35 report by Dr. Montgomery for both of these individuals.
Yes.
And that will be a factor that the court will consider at a final hearing. So it's not necessary. I mean, you can file anything you want to, clearly, but I'm just simply saying, I'm not saying you've got to file a motion to require him to undergo psychological or additional mental health treatment. So,
Your Honor, if I may, while I was calling around to get the prices on the psychological evaluations, the places I called explained, and I went all the way from Memphis, all the way to East Tennessee, which I'm sure is not going to be available now. They were many months out. When we had our hearing, I said, if we can wait till February, I had one scheduled, it was $750.
I'm giving you 15 days to elect whether or not you want to do it. I'm not saying you have to have it done within 15 days. You have to elect and identify who you're going to have it with and when that's going to take place, and inform Ms. McLeod and Ms. Conti and Ms. Coffenberry.
Thank you. Yes, sir.
Let's move to the next motion, which is to the motion to waive mediation and set for trial. Mr. Conti, you are entitled to ask her a question. This is about, again, not going to be where you get to make a statement. This is where you get to ask questions. It must be in a question form, and it must be relating to the issue about controlling the conduct of discussing the case with the minor children.
Now, is it also her conduct in discussing the case with the minor children?
You can ask her questions about it, yes.
Thank you. And you're under oath. I'm going to remind you when you're under oath. Have you ever told Stella or Leonardo that I'm not feeding them?
No.
Your Honor, I'm going to ask if my daughter is able to testify. She's 14 years old, and she requested to speak to the judge in this.
You're going to ask another question?
Yes,
You're
sir.
making statements about your intent And
I was asking if she would be able to, but I have many more questions.
stick with cross-examination and where you're asking questions of the witness.
Tina Conte, have you ever told the children that I have been abusive to them?
I have mentioned during your
Is that a yes or a no?
outbursts that you are verbally abusive, yes.
Okay, so you're telling the children that I'm verbally abusive?
Only when we are subjected to certain situations, I can't glaze over what's happening in front of me.
Have the children told you that they are scared of me?
Yes.
And what is the reason that they're scared?
You're verbally abusive.
Object, Your Honor. Mr. Conti is asking for her to testify about what the children said here. But well, no, when I try to do it, he had an objection to me doing it. So if I can't do it, I don't think he should.
Sustained. It's the same objection that Mr. Conti raised, so the children's statements regarding verbal abuse would not be admitted.
Do you have custody of the children, Tina?
I do.
Okay, who granted you custody of the children?
It was just an unspoken, I don't know if it's considered a rule, but the kids have been in my custody their entire lives. And when we left the marital property in November of 2020, they came with me for their safety.
Okay. Isn't it true that you took the children from Rodney County and you refused to let them see them going all as far back as when you abandoned me in 2020?
I'm sorry, you need to be more specific on dates that I withheld time
Sure.
from you and the children.
Have you ever denied me access to the children?
Again,
I don't
Mr.
recall.
Conti, I'm asking that you specifically address the issues regarding the controlling, the motion to control conduct has to do with discussing the case with the children. So that's what we're talking about right now. You need to stay focused on that.
Okay, sorry. During, on June, do you agree that you have fostered a sense of encouragement for a relationship with me, with children?
Explain that, please.
Have you encouraged a good, helpful, fruitful, meaningful relationship between the children and their father?
I don't understand that question.
It's nothing to do with my motion.
It has.
How does that relate to the question of discussing the case and the Rule 35 evaluation with the minor children?
Because Tina Conti has resorted to, my daughter has had emotional issues. She mentioned that Leonardo had his anxiety. My daughter has called me to come and pick
Which daughter?
Stella Conti, I'm sorry. My minor daughter, Stella, has called me to go pick her up from school because she was having an anxiety attack. I went to go pick her up. Her mother wouldn't pick her up. When I got her, my daughter was having an anxiety attack. Her mother locked her in the car. We called the police. There was a police.
Again, what does this have to do with the motion that's before the court regarding discussing the case and the Rule 35 evaluation?
Because Tina Conti continually threatens to call the police on me when my daughter is asking me to come and help her. The last time, she called the cops because my daughter was being abused. She had recorded her grandfather eyeing her up. She told me.
All right,
she
I
asked me to
sustain the objections. Limit your questions to the testimony that's been offered about the fact that you have allegedly discussed the case with the minor children and you've allegedly read to them portions of the Rule 35 evaluation. Stick to those issues, please.
Okay. Have you witnessed Amelie Conti stating that Rodney Conti is suicidal?
Yes.
Did this happen in front of the children?
Again, Your Honor,
Explain
I
that.
object. He's asking for statements made by other parties.
Sustained.
Tina Conti, do you recollect you and Amelie Conti speaking about my mental state in front of the minor children?
You would need to be more specific.
On a weekend visitation, Leonardo and I were having a discussion. Leonardo wanted to call you. I'm sorry. I'm not trying to round it up. I'm trying
One
to.
view at a time, please. Your objection is what?
I'm sorry, Your Honor, he's looking to testify more, or question her about statements made by the children. He's also testifying about statements the children made to him.
It is not in the form of a question. I sustain it as to the objection as to the form of the question because you're actually making a statement rather than asking a question.
During a phone call with Leonardo Conti, did you or Amelie Conti tell Leonardo on the phone that I was suicidal?
No. She did the reverse. He told us.
Okay, I'm sorry.
No, told us. I didn't say
Okay.
anything about that. I didn't know about it.
So what led you to call the police on me for a welfare check for the children with Humphreys County?
Yeah, when Stella called me crying. She asked if I could come and pick her up. She also was hyperventilating. Amelie was in the house and was trying to make sense of what was going on. She stated you were in the barn yelling and screaming. She wanted to be picked up. And when we asked her, are you safe? Are you scared? She said, sort of. And then, of course, Leonardo got on the phone and corroborated you were yelling and going back and forth. So I made a decision to call a welfare check for both Leonardo and Stella. I was extremely concerned.
Isn't it true you often yell at the children?
No,
Have you yelled at the children in the last month?
I do not recall yelling at them in the last month.
Okay, did you discount Stella's recount of George Gillespie's abuse to her?
What do you mean?
Yeah, I'm gonna
abuse?
check. That's also in the intake order of protection that your office about to prepare. He's asking again about what child they are in the house.
Well,
Have you
we'll come back. I'll sustain the objection. We'll come back to that.
have you ever gone through communication between Stella Conti and myself?
I don't recall exactly. I think there was a time when Stella was recording me talking on the phone, and I was asking her about that. Yes,
Have you ever
she was
asked
spying on me. Yeah,
Have you ever asked Stella Conti to record a phone call between her and I?
absolutely not.
Did you ever email the guardian ad litem a communication between Stella Conti and me, Rodney Conti?
Yes, Stella sent me a message on Skype saying that you would not allow her to talk to me. So I sent it to the guardian because you were obstructing communication between me and Stella.
And when was this recording taken?
Recording or email? Which one are you referring to?
I'm referring to an email that you sent the guardian ad litem of an illegally recorded phone call between Stella Conti and I in 2021.
Illegal. I'm not familiar with the dates. I'm not sure what you're talking about.
Okay, have you ever used telephones to record conversations, private conversations between Stella Conti and
All right,
myself?
we're going far afield. We're going to break for lunch until 1:30.
All rise. Ms. Conti, can you state your full name for me, please?
Tina Gillespie Conti.
Where do you currently reside?
I reside at 376 Darrell Rye Road in Erin, Tennessee.
And can you tell the court the names of your minor children?
Leonardo and Stella Conti.
And how old are they?
Leonardo is 12 and Stella is 14.
Okay. Do they live the majority of the time with you?
Yes, they do.
What is the father's visitation schedule?
Every other weekend from Friday, 6 o'clock to Sunday at 6 o'clock.
And you have an older daughter, correct? That's over 18?
I do.
What's her name?
Amelie Kanta.
Does she live with you?
She does.
Can you tell the courts how things go at the pickup and drop off of the children? Give us some examples of how the communication is between the two of y'all and how the children have been influenced by Mr. Clementine regarding this matter that's pending before the court. In fact, could you just start out talking about what Mr. Contact told the children about this proceeding?
Well, Leonardo did come to us and state that.
And when was this?
This was several weeks ago.
Okay.
To give you an exact date, unfortunately, I wouldn't be able to do that. I'd
Was it
have
in
to
the
look
month of
at the
September?
calendar.
Was it in September? But this year?
No, actually, he told them about his parental evaluation in August.
Okay. Are you talking about the Rule 35 evaluation?
I am.
Okay, so Mr. Contact discussed that with the minor children?
Yeah, the way that it was explained to me is that Rodney had brought Stella to a fundraiser at the Houston County Middle School. She is part of the band, and they were doing a car wash. Leonardo explained that the day was going pretty fair. And once they got into the van, Rodney's van, he started to talk about the case. And he was upset and yelling. And when they got back to his property.
Object.
You object?
Yeah, that's hearsay. It's clearly a lie.
Your Honor, testimony of children is allowed to court in cases of abuse allegations under, I believe it's the.
Well, it's allegations of sexual or physical abuse of a child or constitute an exception to the hearsay rule. Statements by children regarding physical or sexual abuse, but statements about whether or not someone has told them something is not part of that exception to the hearsay rule.
Well, we can have Leonardo come in and testify for that.
I sustain the objection.
So
So if I can't speak of what they've told me.
tell me what you've seen.
I mean, I've seen a lot of anxiety.
Talk about how.
Leonardo has fits before he has to go over to see Rodney.
What does that mean?
I object.
Your objection is what?
I don't see how you can physically see anxiety. And
I asked her to elaborate.
But let him finish his objection. When you're making an objection, you got to stand up so I can know that
I
you're
object
objecting.
because she says she sees a lot of anxiety. Okay? I don't see how you could see anxiety. But if the court will allow this to see anxiety, then when I'm cross-examining, I'm going to explain all of the stuff. But I have physical evidence of it.
Overrule the objection. Anxiety is something that can be demonstrated through the physical reaction, the obviously outside or outward manifestations of anxiety. So overrule the objection.
Can you describe how Leonardo acts before he goes to visit with his father?
Surprise.
Go into detail about that.
He's on the cusp of hyperventilating,
What does that look like?
breathing in and out, crying, rocking back and forth. What can I do? Why don't I have a choice? Why am I forced to go? And I have to explain because I've been forced to do this. This is
I
the,
object. It's hearsay.
No, Your Honor, she's talking about what she's saying.
Overrule. It's not hearsay. She's explaining what her response is to the child. Hearsay is a statement that's made outside of the courtroom that's offered inside the courtroom to prove the truth of what's in the statement. So her response is not being offered for the truth of the matter. It's being offered to show what she responded to the child.
Does he do this regularly?
he absolutely does.
How long has this been going on?
Oh, since Rodney's first official visit before I actually hired you was March of 2022. And that's when I started seeing the anxiety in him. And Stella had moments of it, but it was definitely more Leonardo expressing that he was not wanting to be around Rodney.
And it's a consistent base, a consistent thing that happens.
Absolutely, yeah.
Has Mr. Conti ever made any remarks to you about the situation with the children, the custody, the going ad litem, other parties in the matter? Does he talk to you about any of those things?
He used to.
What were some things that he would say?
You don't have custody. Who told you you have custody? You're keeping the children from me, even though he sees them every other weekend and holidays. I'm confused about that.
Did he ever talk to you about these things in front of the children?
He sure did.
So he
On
discussed-
video calls, things like that. Yeah. Zoom call or on the phone, Skype is what they call it. And I've asked him to stop and he wouldn't. Mainly a lot of monologuing with all of us present. So yeah, they've been exposed to this for quite a bit now.
Do you discuss the case with the children?
I don't.
Do you talk about Mr. Conti to the children?
I don't.
You don't talk about these proceedings in this court with them?
No. In fact, I didn't mention this day to them. It was Rodney that mentioned that this was going on. They didn't even know from me. They found out from him. So
Okay. Does Mr. Conti often send you emails accusing you of being certain ways and doing certain things?
he has abstained from the emailing me.
But he used to.
Oh, yeah, I've got tons of those, yeah. Which that's what brought the protection order originally.
I object, Your Honor. That isn't what brought the protection order. She did not produce any emails going that doesn't.
Overruled. That's not a legal basis for an objection.
All right. I don't have any further questions right now.